Good morning and welcome to another episode on the future of Europe. I am Mam Toure, your host, and today we have a very special guest joining us, Christie Leong Hane. She is a student at the University Catholique of Lille in the Master International and European Law, and we'll be discussing the directive on the protection of whistleblower and its implementation in Polish national law. It's a privilege to have you with us today, Christie. Thank you for taking the time to be with us.
Thank you for having me.
Let's begin by talking about the directive in question. Could you tell us a little bit more about it?
This directive in question dates from the 23rd October 2019, and it is on the protection of persons who report breaches of union law. It is also called the Whistleblowers Directive. What is also interesting about this directive is that we had some resistance from Poland to implement this directive into its domestic law. And for that reason, a case was referred by the Commission to the CJEU through an infringement procedure, which ended with Poland being sanctioned with a lump sum of 7 million euros and a daily penalty of 40,000 euros.
Thank you for this explanation about the directive and Poland's resistance to it. This seems like a particularly interesting case, considering the legal and political tensions involved. So what sparks your interest in this case?
Because this case boils down to Poland not accepting the primacy of EU law. And since joining the EU in 2004, Poland has increasingly challenged this principle. Cases like the 2021 judicial reform, where the CJEU ruled that Poland changes undermined judicial independence, illustrate how Poland has attempted to reshape its legal system in ways that conflict with the EU standards on the rule of law. And in the same case, the court explicitly stated that national judges must apply EU law over national law, even if the Polish constitution says otherwise, which shows the standoff between Poland's national law and the supranational law, which is the EU law. As you can see, the primacy established in the cases Van Luz and Costa v. NL doesn't have the same power than provided by these cases.
Thank you for this context. Returning back to the case, how did the court evaluate the severity of Poland's failure to implement this directive?
The court considered the severity of Poland's failure on the basis of the clear and significant delay in transposing the directive. It noted that the directive had a strict deadline and Poland failed to meet this obligation during a long period. The court reminded that the protection of whistleblowers is a key element in maintaining transparency and accountability in governance, which are fundamental values of the EU. Given the importance of that directive, the court viewed the failure as a serious breach, especially because the protection of whistleblower is linked to fighting corruption and ensuring the rule of law. The court also took into account that this delay was not due to force majeure or unavoidable circumstances, which contributed to the severity of the violation.
So thank you for that answer. When it comes to defense, though, what are the arguments that Poland used in this case, and how did the court evaluate them?
Poland justified the delay in transposing the directive by citing the impact of COVID-19 pandemic, which disrupted legislative processes and shifted governmental priorities. Additionally, the influx of refugees from Ukraine due to the war created further administrative and political challenges, as resources and attention were redirected toward managing this humanitarian crisis. According to Poland, these exceptional circumstances allowed to justify this delay.
Okay.
The court rejected Poland's argument. It found that while these challenges were significant, they didn't directly prevent Poland to meet its obligation. The court emphasized that exceptional circumstances don't exempt member states from EU deadlines, especially when the directive aims to protect fundamental rights like transparency and the rule of law. Essentially, Poland didn't prove a clear link between this crisis and its inability to act. So the delay was considered unjustified.
Okay, thank you for that answer. But why didn't the court accept then force majeure?
Because for force majeure to be accepted, a member state must demonstrate the presence of extraordinary and unpredictable events entirely beyond the control that absolutely prevented it from meeting its obligation. And the CJEU generally does not consider administrative, political, or financial issues as sufficient grounds under this strict standard. This is illustrated by several cases, as Commission v. France in July 2005 and Commission v. Greece in 2000. Additionally, in the case Commission v. Slovakia, the ECJ recognized the unforeseeable and exceptional circumstance, but specified that the state is not exempted to fulfill its duty to keep the Commission informed about the situation.
Thank you for your explanation for this case. Now I would like to hear your opinion for the future of the protection of whistleblower according to this case. I mean, how does this ruling impact whistleblower protection within the European Union?
This ruling shows how important it is for the Union to create a clear and common rule to protect the whistleblowers. Before this directive, the protection of whistleblowers depended on each country's own laws, which were often different and sometimes not strong enough. This made it harder for people to speak up because they were not sure they will be protected. And with this directive, the EU makes sure that whistleblowers are better protected everywhere, creating a more consistent approach across the Union. This ruling will likely encourage more people to come forward with reports, knowing they are protected, no matter which country they are in. So in the end, this case helps increase transparency and trust across the EU, making it clear that protecting whistleblowers is a priority.
Thank you again, Christie, for sharing your insight with us. It has been a pleasure talking with you. Mam Touré and Christie Leong Hane on the implementation of the Whistleblower Protection Directive and its implementation in Polish national law. Thank you very much.